So, good morning, everybody. Welcome to 15 Minutes with Lori. This morning, we're going to continue reviewing parts of the contract. It's always good to continue to talk about the contract because sometimes certain situations pop up and you may not be aware of how to deal with it. And that's kind of why we're here. And it's just an ongoing thing to continue to always review the contract in little bits. And that's why we're here. So closing and possession is what we're going to talk about this morning, because I know there's still some confusion out there about when closing is and when possession can be handled. So note, all parties are encouraged to use the same title company to reduce any risks. If seller does not close at the same title company as buyer, or seller's choice of title company does not have a common underwriter with buyer's title company, the seller will be required to sign a notice of closing or settlement risk acknowledging that their settlement funds are not protected by the title insurance underwriter. So we've got to make sure that the buyers understand that, and the sellers as well. So there was a situation this last week where the seller had their title company and the buyer chose to use Title Premier. And as the process was going along and title was complete, the buyer's attorney required that they move to their title company because the lender would only close at that title company. Now, by rights, contractually, the contract said that they were closing at Title Premier. So in the end, the buyer did sign an amendment, and the seller did too, to move the closing to their title company that the lender required and that their attorney required. However, the title company has done all the work. That is really their position, whether or not they want to charge that buyer. In this case, they went ahead with it, and I'm not sure if they're going to charge or not, but make sure that your buyers or sellers, depending on who it is, if they choose to move to a different title company, make sure they understand that there could be repercussions for that. And they may have to pay that title company for the work that they did, okay? So each title company might be a little bit different. So always make sure that they're aware of that. The closing, in parentheses, of course, is the exchange of the seller's deed for the total purchase price. So that's when they go in and they sign all the documents. Seller shall be deemed to have received funds when funds are received by the seller or the seller's title company. So at a minimum, the funds must be at the seller's title company. I hear a lot of agents say, well, the title company said that it's funded and closed. They're not the ones who determine that. Maybe on their end, but not on our end. So we've got to make sure that according to the contract, and who has those funds, because there's a lot of times that the buyer's title company will say, well, we've wired it, it's funded, and it's closed, and the agent goes with it, and they tell the listing agent goes with it, and the possession is given. But if something goes wrong in between there and that seller doesn't have that funds, let's say it's a Friday afternoon, and this actually happened 2 weeks ago. The funds were not in the seller's title company by the end of the day on Friday. Buyer was irate because they wanted to move in, but according to the contract, it was not closed because of that, because the title company for the buyer said it was closed, they said it was funded, but the seller's title company did not have the funds yet, okay? So who do you listen to? We listen to the contract. If the seller's title company doesn't have it, it's not closed, period, okay? The closing of this sale shall take place on, and you put in a date, or any other date that both parties agree in writing. Buyer will close at, and we enter the title company here, typically the same title company that you have as the earnest holder, the escrow holder, up here where you have on line 37, whoever the escrow holder is, unless it's called Banker Premier Group. If it's the title company, that's where they would want to close, okay? The title company which provides title insurance. Regardless of who closes for the buyer, seller may close at the title company of the seller's choice, so they can close wherever they wish to. Title will pass when the sale is closed. Seller to deliver possession of the property and keys to the buyer no later than check 1. It will either be closing or a time and date. I personally, in the past, when I sold property, I would just check closing. Because if your sale date changes, okay, you don't have to change that possession date. Plus, if you put in a time, let's say you put in noon is when possession is, seller probably doesn't have their funds yet. Title company for the seller probably doesn't have their funds yet. And if something goes wrong in the afternoon, but they've been given possession, they can move in. So always, I personally would always check closing. Jack or Josie, do you ever do a time and a date versus the closing? If so, why?
No, unless I will sometimes put a time unless I've been having some trouble on the other side, that I was just not certain that whoever my client was, like if I had the buyer would have possession that day. So sometimes I'll put a time, but usually I don't.
Okay.
Can I ask that scenario that happened when the lender said that they had to close at a certain title company? Was the seller like an investor or something, or?
No, it was strictly a homeowner selling their property, and it is a buyer buying, a buyer who was going to take possession and live in the home.
But I guess I'm confused as to why the lender usually doesn't care.
Yeah.
Closed with the title company,
There had been some title issues on the property, pretty major ones. And I think the lender, they always use a certain title company. And these were out of state buyers, by the way. They're moving to St. Louis. So their lender was very adamant that they wanted to make sure that the title was free and clear at closing. Even though our title company was going to provide that, they felt that they wanted to use theirs. I mean, sometimes attorneys will take precedence over anything. Not always, sometimes. So, the buyer in the end said, no, I want to go with what my lender's, recommendation. They were requiring it, but contractually they couldn't. But the buyer wanted to go along with what they were saying, so it was good.
Yeah.
It was a sticky situation on the property. So, yeah. Any other questions? Okay. So moving along, after you would put in either the closing or date and time, which again, I would always recommend the closing. But in no event prior to closing as defined above, all parties agree to sign closing documents at a time that facilitates this possession. Note, if possession is to be delivered on a day other than the closing, as defined above, parties should complete the appropriate rider. And so that's depending on if the buyer is taking possession early, that rider is the possession by buyer prior to closing. If the seller is going to stay in the home past closing for a couple of days, couple of weeks, then that is the possession by seller after closing. So those forms would need to be filled out. Each party would have to obtain personal property insurance during that time, and they would need to obtain the utilities themselves. So, but those riders are really only for a short period of time. Okay. Deed as directed by buyer, except for tenants lawfully in possession, seller warrants that the property will be vacant and free of personal property, except as otherwise provided herein, and debris at time of possession and delivered to buyer in its same condition, together with any improvements or repairs required by this contract. Ordinary wear and tear are accepted as it was on the date of this contract. Buyers should change the locks and codes following possession. Buyer and seller authorize the title company and or closing agent to release to broker signed copies of the closing statements. So the seller must be out of the home prior to closing, and they must have it pretty much like what we would call broom-swept. So, because it says free of any debris, any trash, I would recommend to the seller to give it a quick vacuum or sweep, wipe things down. That way respectfully, the buyer can, maybe just move in, or they may want to come in and clean themselves. But anyways, they need to make sure that everything is gone, trash included. Okay. If there are any improvements that were required by the inspection notice, or maybe the FHA appraisal, predication work, that stuff needs to be done prior to closing, and the buyer has the right to walk into the home within 4 days prior to closing to make sure all those things are completed. Okay. And then also always recommend to your buyer to change the locks after closing. You never know if, a former owner has a key, or maybe a family member who hasn't been around for many years and they still have a key. So you got to make sure that they understand that it's important to change those locks, because we don't know where the keys are at. Okay. And then also, it does authorize at closing that all parties get both sides of the signed HUD, the seller signed and the buyer signed. Okay. Parties are cautioned to always call to confirm instructions before sending any funds via wire transfer. Wire fraud is very real. We have seen it. It has been attempted on us. Thankfully, we caught it. But your buyer is never going to get just an email from the title company to wire with wiring instructions at closing. They will contact them, and there will be a secure method process that they use to have the funds wired. Okay. So always make sure that your buyer understands that there is wire fraud, and that they should either check with you or check with the title company to make sure what the instructions are. Okay. Any other questions? I guess Bill had to go. I know Bill is there. Bill, do you have anything you'd like to share this morning?
No, I don't actually. I'm just trying to get everything done for accounting stuff now that Dave has stepped down, and get Mark all set up. Guys, just be patient with us, and if you see anything, let us know. But we're going to be modifying things starting hopefully next month. When you guys get a closing, you will actually get an email from accounting at cbphomes.com, and it will have your commission distribution statement. So you'll have an actual electronic copy of that. So we'll be sending it from there to make it easier, so you guys have your statements. I'm trying to be more tree friendly here.
Yes. And don't forget, Monday we have Bringing the Blue to You. If you have not signed up, it's going to be a great time, and you're going to learn quite a bit. And it is absolutely free. We've sent out the links, we've sent out the QR codes, so make sure that you get signed up. Besides, we have been challenged by Paul Baker Brown for the most attendance. So we got him, I told him, bring it. So we got to make sure that we show our faces there and our presence in St. Louis. Lastly, on May the 8th, if you haven't seen already, we are having a celebration for Dave Freebersizer here at the district, starting at 4 and then ending when Dave is ready to go. So you all have a great day, and we will talk to you soon.
Be dry, folks.
Bye.
Thank you. Bye-bye.